taps, coffee brews, we're like, here we go. I'm the broken baker, chat's coming in slow. Lawyers pace, jury sits, the room hums alive. Leaning forward, screens glowing, this is where we thrive. This stream from roll real, chat's the heartbeat, loud and clear. Trials come and go, but we stay near. Crimes up, crimes down, you're always here. Drops, lawyer jumps, tension spikes, we freeze spray, the jaw drop, chats and lower yikes. Not mocking the mess, just sharing the rush. Even silence feels like a crush. We read this dream from roll real, chats the heartbeat, loud and clear. Trials come and go, but we stay near. Crimes up, crimes down, you're always here. So grab your mug, don't be late, the baker's life will set it straight.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be. And welcome to day 4 in the Dustin Duren case, where Marissa has promised me that today will be the day that the state rests. So probably sometimes next week is when they're going to rest. Blame Marissa. And today, as if you are considering maybe sending $2 my way, might I suggest maybe helping a friend of the channel out. Carmen, who is the daughter of AJ, has just recently gone from working for the federals to the local police, and they only give her the basic of basics equipment. So she has asked me if I would like to share her Buy Me a Coffee link, and if anyone wants to help her get some better body armor, just to keep her safe. Please consider her today instead of me. Always consider everyone else instead of me. But it would be very much appreciated because I like AJ and I like Carmen. Gabby, not a fan. But if you are so inclined, please consider Carmen instead of me. Because the most important thing is she's safe out there. And I have to do this also.
Yo, stop the chat. It's a birthday vibe and we're all in that. Could've gone out, could've chilled offline, but you showed up and that's just fine. No balloons, no big parade. We've got better this crew homemade. Happy freaking birthday right here live. You showed up, now we thrive. Cake emojis in full attack. Streams on fire, no turning back. On your birthday, and you're here. That's legendary behavior. Thanks for showing up today. This stream's your party, press replay. No balloons, no big parade. We've got better this crew homemade. The happy freaking birthday right here live. You showed up, now we thrive. Cake emojis in full attack. Streams on fire, no turning back. On your birthday, and you're here. That's legendary behavior. Thanks for showing up today. This stream's your party, press replay.
Our good friend, one of my favorite people in the whole entire world, Sue, is turning 23 years old today. So let's all wish Sue a happy birthday, because even though Jamie and the kid, Marissa, Brandon, Zach, Danny T, Iris, always treat her really, really bad, I like Sue, and I'm very, very happy that she's going to spend her birthday, well, part of it, with us. So wish Sue a happy birthday. 23 doesn't come around that often. No, we're not in sub-only mode. It's open party for all. Because we're only 50 people here. This case is so boring, no one shows up. But wish Sue a happy birthday, and she's probably going to be in her pool later getting drunk, which is absolutely fine. It's not a birthday thing, it's just a Friday thing. Well, it's a day ending in Y thing, as long as it's Sue. But I, for one, like her, even though a lot of people says, I really like her. I have never said anything bad about Sue. So I think that was the promotions. Well, that's why you need to drink some more. Hey, Opal, been a second. But again, please consider AJ's daughter so we can keep her safe, keeping us safe, and send a happy little thought towards Sue. And I don't know why we ended when we ended yesterday, other than he wanted to hit 4 o'clock, even though he had told the jury that they were going to stay late, because they finished what probably was the last witness for the state, because he was the one who interviewed him. I don't know why we're here, but I never do. It was he was admitting to everything, and there was nothing like self-defense in what he said in the interview. So I'm thinking maybe the cross-examination, where we heard part of what the defense started cross-examining, it was just, oh, was this word wrong? Was this word wrong? Or did he say that he did this? I don't know if it's because they were going to go longer, but they didn't ask any good questions. And maybe the state wanted to recross and it would last too long or something. I don't know. But the state should have rested yesterday, in my opinion. Start the defense off today. I don't know how many they're going to put on the stand. He needs to take the stand and be very, very believable. Or else this guy's fried. Hello. I hate that they switched the names again. I hate it. Gennady, well, as long as you're listening, you can hear all the funny things we're saying. Can you clean my house too, Jen? Well, that's for tomorrow. That's Saturday work. You're here because of me. Oh, I'm sorry. Hey, I hate Cowbell. Yeah, that's your new name on this channel. Now I have to figure out all the new names that I'm going to give you, because these stupid things. And again, you could be Bornholm. That's an island in Denmark that we stole from the Swedes. But I don't know. Maybe I got it wrong. Maybe other people heard something in the interview. That fight over the kid where she was hurting the kid, I just didn't hear that in his statement. The kid were making noises, but both of them were trying to grab that kid. So of course something could happen. Hey, Noodles. Oh, well, don't have us on while you're babysitting, because I might at some point use Jamie words. Yeah, but again, then they'll change it at some point and it'll be messed up. And I can't change my name because I'm a brand account, and it's just stupid. I turned blue. I'm always lurking, but love you all. Oh, thank you. I'm not your mom. Yeah, Rianne, I know you. And Maylin, yes. No, it's because your name is good. Sarah from San Diego. Hello and good morning. Did my daughter go look at the house for you? No, I talked to my I talked to the idiot yesterday. My daughter called me on the lunch break, so that worked out perfectly, except I didn't really get to eat that much. Well, you don't need it. Shut up, Zach. and he has some days off next week, so he will go and take a look to see if it's good, and then I'll have to talk to my brother about co-signing, because as soon as I can sell this, I have the money for the other house. So it's just that transition period where I need to have a loan at the bank. Hey, Bob. Building the Lego Fortnite llama. Oh, I've been looking at that. I don't watch Fortnite, so it doesn't. That's why I've kept away. But it's kind of cool. I thought I could rename it the No Drama Llama. Hey, Anya. What's the docket number on the Catherine Peter case? We couldn't find it. That was one of the things that the kid was complaining about, that she couldn't find the docket number on the case. I don't know if it's the one that's handwritten on top. Well, a lot of people haven't got a name. It's just when I read your name wrong. So that's when you get new names. Hey, Nicola. Yeah, you're Delulu. Keeping the same picture helps us all. Yeah, but the problem is if you are one of those who chats maybe every 3-4 streams, I'm sitting here thinking, I know that picture, but I don't know that name. And then people get mad. Well, go back to sleep. I woke up last night at 3 o'clock and I couldn't fall back asleep, so I started a stream at 4 o'clock. Then I got back to sleep, and I've been on the Cougar Patrol at my disco this morning. Hey, Deb. Your handle is always the same on every social media site I use. YouTube has just made things difficult. Cowbell acceptable. I'm a band geek. Yeah, but normally you need more K-Bell. So you must be Cowbell. You found an old case that was closed. Yeah, she has a lot of cases she's pled guilty to, but right now she has 2 outstanding. And I talked about it this morning, and Mary Bagwell was in chat, and I was sarcastic. And after I thought, oh my, not everyone understands my sarcasm. So I reached out to someone to please contact her and say, hey, when he said that, well, Krusty Pandy said something else, and we all trust the Cross, that she knew I was just making a jokes. Hey, Carly. No, but your name is also the same, Inspire. Discord is worse than Twitter. Well, that's because you come the wrong places. My discourse is filled with nice people and Sue, but you can go in there and you can talk about a lot of cool things. It's because they claim this will keep people safe from online harassment. Well, not much. We're just waiting for the trial to start. And nothing is happening. Yes. I don't know what a build script is, but it sounds interesting. Velo, I watch every day, but chat once a month. Yeah, every time I'm thinking, oh, I haven't seen Velo in a month, then you just write something, and I can tell, oh, you've been watching. So, but thank you for hanging with us, even though you can't be on the. How? What makes no sense? I pop on and off there. It's fun. Yeah, it's actually. I don't go into the voice chat that much. I should be more active in there, but it's just I stream so many hours a day that when I'm done, I just want to watch a stupid show or a stupid movie and relax a little bit, because then I'll wake up 4 hours later and think, I could talk about this, and then I go live. But I'm glad that when I woke up last night, I saw that you were all hanging out in there. The build script is the software that makes the software that people use. Oh, that's it. Okay, thank you. Well, Boober, you are here. Yeah, but it's so nice when people just check in, let us know, because sometimes we worry a little bit. Helen from Holland, I haven't seen Helen from Holland in about a month. Totally not a Russian. Yeah, he went on vacation. He goes away for a little bit. But Helen is always the first one here, and I haven't seen her in a month, and now I'm concerned. Pimpernella, we know, is in the hospital, so I just hope nothing happened to Helen. Thank you so much, Holy Mug. I chat when I'm at my computer. This is my last busy weekend until next year, so I will be able to watch more lives, but I do make sure I'm on the replay crew when I miss one. Thank you so much. Every view counts. I chat twice a day, but only watch once a week. Well, Dave, you watch more than you stream then, but also you are 6-time retired. But thank you so much. And again, thank you, Dave. It's always appreciated. If you are considering a super chat today, please consider helping out AJ's kid. AJ has a daughter who is a police officer, and she used to work for the federal branch where they gave her decent armor. Now she's going to work for the state police again, and they don't provide her with that good of a protection. So she is trying to raise some money to buy better protection gear. There is a link posted on the top of the chat for a buy me a coffee link. If you were so inclined, please go show her a little bit of appreciation, because even though I don't like most cops we cover, I like her. She's a funny person. I know, Zach. I know. They're fun that age. That's why I want to move so I can get closer to. He's turning 1 next week. Yeah, Zach has abandoned Carmen, so she needs us to help her. Empire is from Australia. No, not Alan Jackson. Sorry, it's alternate juror. I just call her AJ because that's easier than saying alternate juror. So AJ is not that AJ. AJ is alternate juror. She's also a streamer. I have redirected to her chats a few times. She runs old cases at, normally she'll start around 6 p.m. and then they'll watch an older case, and they are sadly a very underviewed channel because it's very friendly chat. Sadly, Zach is also over there sometimes, but most of the times it's a good chat. Um, and she has a daughter, Carmen, who will also be on stream, and she is in need of a little protection. Hey, Mimi. He looks very different than when he got arrested. Yeah. If you could set the rest of Sweden to Australia, I would be a happy man. Hey, Hellfish. Thank you so much, Judy. We're not mentioning Gabby. Gabby, I try to keep her. Gabby is AJ's sack. You had Western and plates donated as MPs. Yeah, but sadly, they don't take as good care of the state troops as they did with the federals. So again, if you're considering donating anything, please consider AJ's child instead. Shouldn't say that because she's a grown woman. It's Carmen. Hey, Frankie. Kevin, you know I'm right. And you're just embarrassed that I'm always right and you're always wrong. No, isn't it? It's way too fast, and I only seen him like 10 times in this last year. That's why I want to go closer so I can see him way more. Mhm. And I just got a picture of him. Oh, I'm sorry, Panella. Even though I despise all that crapply, I'm sorry that Yoshi isn't. Yeah. Can you send the stuff you got to them? I don't know. I don't know how it works. But maybe you can reach out to Carmen. She's on Discord. Can I share some? Help us. Are you not on Discord? Okay.
Good morning, thank you. Please be seated.
Hmm.
Okay, members of the jury, thank you again for your service and your punctuality. As I ask you every morning, because there is a media presence with respect to this jury, please, I would ask you now to raise your hand if you have had any exposure, even if it was inadvertent, relative to any of the media coverage with respect to this matter. Let the record reflect that none of the jurors have raised their hands. Thank you again for your adherence to my instructions. Thank you. And Attorney Kettle's ready to proceed.
Where the hell are you?
Detective Sergeant, you're still under oath, sir.
Yes, sir.
Thank you.
There you are.
Detective Sergeant, I'm going to back us up a little bit and just go through and some bite.
I sent you her.
Okay.
So we were talking about the incident itself, what Dustin told you about the incident. He said it happened super fast.
Yes.
He said, I mean, there was, again, it was like training to where it was, he said, I mean, there was, again, it was like training.
Yes.
He said, to where it was just grabbed it, cocked, grabbed Elwyn, and then right when I shot, it was just immediately, I grabbed Elwyn and like ran out of the house.
To the car.
Yes, I'm doing it in bite-sized chunks here. Yes.
Okay. Yes.
And just immediately ran out of the house and put her in the car.
Yes.
You turned off the audio. You turned off the audio. Hey, Jamie. They turned off the audio.
Morning. Oh,
Didn't have injuries.
Yes.
She didn't.
Correct.
He loaded the car up.
Yes.
He got the kids in the car.
Yes.
He was thinking, at some point, I'm going to turn myself in.
Yes.
But first, he was going to spend some time with his kids.
Mm-hmm. Correct.
He said he drove to Concord.
Yes.
Once he got to Concord, he sat with Elwyn and Valen again.
Yes.
And at that point, they were both good and they were happy.
Yes.
He called his mom and told her what had happened.
Yes.
And he told her to call the cops.
Probably should call the cops is my recollection, but something to that effect, yes.
He told his mom he was going to turn himself in.
I believe so, yes.
He told her he wanted some time with the kids beforehand.
Yes.
He told you that after he talked to his mom, he turned his phone off.
Correct. Went dark, I believe is what he said.
He said went dark, and he said, I turned my phone off.
Yes.
He said he drove to somewhere in New York State.
He believed it was New York State. Yes.
He and the kids got a few hours sleep.
Correct.
He woke up and initially thought, well, I'll just surrender at a random police department.
Yes.
But then he decided he should probably do it in New Hampshire.
Correct.
And by do it, he was referring to surrendering or turning himself in.
Yes.
So then he started heading back.
Yes.
He decided to go to Concord and then just surrender there.
That was his plan, yes.
But he wanted to just sit down with the girls and just have breakfast somewhere.
Yes.
Just a couple more questions on what Dustin said in relation to his training. Dustin said everything was so fast. It really was like training. It was instant.
Referring to his marksmanship training, yes.
He said it was like muscle memory.
He did say that.
He said it was his training coming out.
He did say that, yes.
One moment.
It's such a stupid argument.
No further questions.
Oh, I know.
She's going to end on that?
That was so lackluster.
Just because she has the same hairdo as Zach, she should be better than Zach. You don't have to recross that. Just let it stand alone how stupid it was.
Sergeant McLaughlin, just 2 questions. How many police stations or police barracks are in Keene?
So there's a state police barracks in Keene, so that's 1. The Keene Police Department is 2, and the Cheshire County Sheriff's Department is in Keene as well, so that's 3.
And to the location where he was originally stopped by, or initially stopped by police, he passed right by your barracks, is that correct?
He even commented that he saw the sign for the state police barracks.
And he avoided that.
Yes,
Now, how many police stations between Keene and Concord?
a lot. You don't expect me to know how many, do you?
No, that
Okay,
many, right?
a lot.
You can't even judge.
And even from the Vermont border into New Hampshire, there's at least Chesterfield Police Department.
Okay. Did the defendant talk to you about whether he had a connection to Concord, New Hampshire?
No,
Now, everything in the defendant's statement, all of the words that he provided to you, that's what he told you, correct?
that's correct.
Anybody else tell you those words?
No.
No other questions?
Recross?
No, Your Honor.
Okay, thank you. Can Detective Sergeant McLaughlin be excused?
Come on, state, rest.
Yes, Your Honor.
Okay, thank you.
Thank you, Ron.
They couldn't have just waited 5 minutes after to finish.
Yeah.
Such a waste.
And may I approach the monitor?
Certainly.
The monitor. I really don't know what's going on. This is a weird case.
Sure.
Yeah, they could have finished that yesterday. It's absolutely absurd that we had to wait for that. And then the defense could have had their witnesses ready to go, because now the defense, with their preparation, they probably don't have the witnesses ready to go, and, oh, we'll be back after lunch.
Your Honor, at this time, the state has no further witnesses and we would rest.
Okay. All right, thank you. Okay, members of the jury, at this time, I know that we just started for the day, but we are going to be taking a break at this point.
Oh my
So
God.
I'm going to request again that you retire to the deliberation room. Please do not discuss any aspect of the case. Do not discuss it with any other member of the jury. If anybody does that, please report that to a court security officer. And thank you, and we'll resume as soon as we can, okay? All right.
Do you think?
Boop. And the traditional poll has just been put up. The state has rested. What would you vote? Yeah, that it's absolutely ridiculous. Oh, by the way, Jamie, didn't you miss something?
What?
Oh, you don't care about Sue. That's okay. I forgot that you don't like her.
What did I
I'm-
miss?
It's Sue's birthday.
It's Sue's birthday today? Did you put it somewhere and I'm not reading it?
No, I only talked about it for 10 minutes when I started my stream.
Oh, well, I wasn't here right away. I had to finish some things so I could jump
You
on.
know you
But
can-
happy birthday, Sue.
No rational trier of fact could find beyond a reasonable doubt. The state has disproved the affirmative defense of others, and therefore the court must dismiss all 4 charges. Specifically, Dustin was justified when he shot Caitlyn.
and all charges must be dismissed. The state offered evidence that Caitlyn died from a gunshot wound to the head and that the gun that was shot was Dustin's and was found in Dustin's car upon arrest. However, the state introduced the defendant's own statements through Detective McLaughlin, which offer enough evidence of justification. And so the burden shifts to the state to prove it was not justified. Dustin told the state in his interview how and why he was justified. Specifically, he described Caitlyn refusing to leave his home. He said Caitlyn was getting more and more aggressive. Caitlyn told him she
How?
was going to take the kids away from him. Caitlyn told him she was going to call the cops and have him arrested.
Yeah, this is
Oh,
just,
scary.
they need to
And
do
was
it.
not letting go.
I know.
She was
It's
again
so
threatening
lame.
to take the kids. Caitlyn was saying she was going to take Valen and Elowen back to Minnesota. Dustin tried to grab Elowen and be like, hey, let go of Elowen. And Caitlyn just wouldn't let go.
We're having the first winter
Caitlyn had Elowen in
rough
a bear
winds
hug,
today.
a two-handed
So
bear
if I'm
hug.
gone at some point, it's the wind.
Dustin tried to grab Elowen a
The wind
couple of
took you away.
times. He couldn't pull that much because he did not want to hurt Elowen. Elowen was yelling. Elowen was crying. Caitlyn was holding Elowen forcefully
I hate
enough
this guy.
to cause her to cry. Dustin said he grabbed the gun, chambered it, and while grabbing Ellen, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Ellen. Dustin said everything was so fast.
No, it's the other way
it
around. I
was
grabbed
like
Elvin and then I
finger
shot her. It was
snapping,
just immediately.
banging. It was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Ellen.
Well, your training is
ran out of the house,
ridiculous.
put her in the car. He sat for a minute talking to Ellen.
Miss Jessica used to be in, I believe she was a Marine. She might have been Army. Miss Jessica, is your first reaction to any problem just to pull out your 9 and start blasting? Is that the training that the American military gives people who work for them? Because this is his defense. I used to be a Marine, so my training just took over. An unarmed civilian, I just plucked her in the head.
Yeah.
And he said he was making sure that nothing
She was the bomb in the Army.
happened to her. He said he was checking to make sure she didn't have injuries.
No.
He said she didn't. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in. But
Trained very
First,
different.
he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627.
Also,
paragraph
didn't
2
he
says,
drive her to
"A
his
person
house? Like, she didn't have a car, did she?
No, and that's the only thing he would change was not allowing her to come to the house. That's
Yeah.
the only thing he wanted to change.
But it's like, where was she gonna go? He had to take her somewhere, so it's not like
Well,
he could have just
he-
called the police
he-
and been like,
That
Get
he
outta here.
mentioned that in the interview yesterday. They had she had a friend that he was going to call, but that was like 2.5 hours away, and
yeah,
he offered to drive her down there, but it was just like something snapped when she said she was going to take the kids.
yeah, that's
And if that's the way you phrase it, then it's not self-defense. Then it's, you could say I was in an enraged state. I was absolutely losing my mind because he was going to take my kids away, and my world just crumbled and I blacked out. That would have been a better defense.
yeah, it's pretty lame.
They haven't called a doctor yet. No, that would be the defense, to call someone to claim PTSD. But again, not everyone with PTSD shoots their wife.
justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlyn used force against Elowen when she restrained Elowen in her arms while committing a burglary. She entered or remained unlawfully in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping or 633-4 interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlyn was threatening to do so. She was attempting to do so.
Did she have the kid? He grabbed the kid and then puked. That's what he stated. This lady said he puked and then grabbed the kid. But according to his own testimony, they were having that tug of war with the kid and the bear hug. Then he grabbed his pistol and took the kid and puked her in the face. Well, in the side of the head.
So she was refusing to leave the home or release Elowen. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Elowen to Minnesota or to New Hampshire. Harassment.
Everyone who's getting mad at her now, this is her job. She has to try and help her client. Is it bullshit sometimes? Yes. Is it enraging sometimes? Yes. She's just trying to give him the best defense. It's a constitutional right.
With the purpose to annoy or alarm another, communicates any matter containing or any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person is actually placed in such fear. In the course of conduct would be restraining and yanking back Elowen. Theft by extortion. A person is guilty of theft as he obtains or she obtains or exercises control of the property of another by extortion, and with the purpose to deprive him thereof. As used in Section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened or to any other person or to property at any time.
What?
Or B, subject the person threatened or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining Elowen. Theft by deception. A person commits theft if he obtains or exercises control over the property of another by deception with a purpose to deprive him thereof. Deception occurs when a person purposely creates or reinforces an impression which is false, in which that
She wasn't begging for money at that time. She was begging for money before she came back with the kids. Yes, she extorted him to pay for a plane ticket to have his kid back. But that doesn't mean it's self-defense. He's claiming self-defense. He's not claiming that she was stealing his money and he had to shoot her.
Yeah.
I'm not understanding. This isn't the right thing to do. This seems, well, it's in front of the judge. It's not in front of the jury. That's because, yeah, she might have been blackmailing him emotionally with the kids to get some money, but again, that doesn't make it self-defense.
Yeah, it doesn't mean you can
did
just
not believe to
take
be
her
true.
out.
Yeah.
Attempting to obtain
No, I need a
Dustin's
better
money,
defense
deception would be
lawyer.
telling Berlin PD that he took Elowen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him. Evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlyn was using unlawful force against Elowen when she was restraining her in her arms, squeezing her while attempting to commit interference with custody in Dustin's home. So she was in his home, she was attempting to commit a felony level offense and using unlawful force. If the court disagrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect to either of those charges. Reckless conduct alleges that Mr. Duren recklessly engaged in conduct which placed another Elowen in danger of serious bodily injury by shooting Caitlyn while holding Elowen. 2 reasons the court must dismiss for insufficient evidence. 1, the facts don't show beyond a reasonable doubt that Dustin was holding Ellen while shooting Caitlyn. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Ellen. He grabbed the gun, chambered it, grabbed Ellen, pulled her back out of the way, and shot. The state alleges that this action was reckless.
So he grabbed
even
her
though
out of the
we
way.
have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting. He knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Ellen, that he pointed the gun at Ellen. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Ellen out of the way. He made sure that she was not at risk. He aimed the firearm away from her. We heard that the gun he used has many safety features and cannot accidentally discharge. In terms of the risk to Ellen, this is no different than if Dustin and a child were at a firing range and Dustin fired, not towards the child, but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired does not, without evidence that the gun was aimed at or near her, rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor, the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Ray NK, 169 New Hampshire 546, defines what endangering welfare of a child means. A person
That's why he wanted to go to Applebee's. They have free crayons with every meal.
is guilty of endangering the welfare of a child when he knowingly endangers the welfare of a child under 18 years of age by purposely violating a duty of care, protection, or support he owes to such child. So the states are required to prove 2 things: that Dustin knowingly endangered the welfare of Ellen, and 2, that he did so purposely by violating a duty of care owed to her. And so again, the evidence here is that Dustin grabbed Ellen from Caitlyn and moved her out of the way while simultaneously firing 1 bullet in Caitlyn's head. He said, "Right when I shot, it was just immediately I grabbed Ellen." He did not violate a duty of care. He acted out his duty to care, to save her from harm, to remove her from the situation.
What harm?
There is no evidence.
Have you ever been bear hugged?
Ellen was endangered. Evidence is sufficient to prove endangerment if it establishes.
No, I would want to know. I want to know how
If it establishes
harmful
that
that
the
is.
offender engaged in behavior creating an actual and significant risk of injury to a child's welfare. The state didn't offer evidence of welfare beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Ellen appeared well-kept and well-nourished. That's what Dr. Robertson said. There was no evidence of the volume produced from the gunshot. We heard evidence of the amount of pressure it takes to pull a trigger, but no one testified how loud the gun was. And the state did not present evidence of how loud a Beretta 9mm pistol is when it's fired.
Oh,
And that's no different, Your Honor, I would argue, that when you take a child to a musical festival with loud music without ear protection.
it is
And-
different.
Also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, "I can see where this is going of like, could it be that I'm endangering Ellen by what I did?" And I would very much say no. And then Sergeant McLaughlin responded, "Yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you were not endangering Ellen." And Dustin responds, "Yes, I was not endangering Ellen." And to follow up, Your Honor, again, they have to prove the mental states of both knowingly endangering the welfare of a child and purposely violating a duty of care. Thank you.
Okay, Attorney Spicer.
Thank you, Your Honor. They ask that the court deny the motion. In the light most favorable to the state, there has been sufficient evidence provided for a rational trial fact to find each element of the offenses charged. I'll note for the court, as this court is aware, it's the defendant's burden at this stage of the proceedings. I don't believe that they have met that burden. That shown that any of the charges should be dismissed. I will start with the murder charges. The defense argued that there has been evidence presented of self-defense through the defendant's statement. I would not agree with that. At this point, I'll make arguments, assuming that to be true, but I would state for the record, I don't believe that that's true. The defendant's statement established that he told Sergeant McLaughlin that he killed Caitlyn Naffziger very deliberately, that he did so because she refused to leave his apartment, that he did so after a day of arguments about things that they had been arguing by his own testimony for months and weeks. None of the statements that he claims that Caitlyn made the day of the murder, that she was going to take the kids away from him, she was going to call the police, are things that were new to him. By his own testimony, she had said similar or identical things to him before in other contexts, and at no point did he shoot her in the head. His testimony, I think, was pretty clear, certainly in the light most favorable to the state, that he killed her because she wouldn't leave. He wanted to put her and the kids in the car so that he could drive them to her Aunt Brenda's house. He was in the process of doing that by his own statement. He put Galen in the car seat and got her ready to go. He was trying to take Ella in so that he could do the same thing, so he could get her into the car and get Caitlyn moving. Caitlyn refused to let Ellen go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her. And so, just for purposes of the record, I don't think this is disputed. With regard to second-degree murder, both the knowing and the reckless varieties, there has been sufficient evidence presented as to each element of those offenses. That the defendant caused Ms. Naffziger's death, and that he did so knowingly, and in the alternative, recklessly, with extreme indifference to the value of human life. The defendant has admitted that he pointed his gun at Caitlyn's head and fired it. He has admitted that he knew the bullet went straight through. He has admitted, in essence, that he was aware that his conduct would cause Caitlyn's death by pointing a gun at her head and pulling the trigger, particularly in light of his statements about his own expertise and his own experience with marksmanship and handling of weapons. So I don't think there's any argument there. I didn't hear anything from the defense about this. And ask that you find that the state has satisfied the elements of knowing and reckless second-degree murder. Again, keeping in mind that there has to be some evidence of self-defense before self-defense that shifts and the burden moves to the state. Understanding that the state does not admit that that has happened here based on the evidence before us. Even if that is the case, there is sufficient evidence at this stage in the light most favorable to the state where the rational trier of fact could find for the state. The case law on this is somewhat convoluted, so I don't want to misstate the standard, but I'm citing State versus Pennock here, 168 New Hampshire 294 at 307. It's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences therefrom in the light most favorable to the state, could have found beyond a reasonable doubt that the defendant did not act in self-defense. And that is an awkward formulation. But I would submit that there is certainly sufficient evidence before the jury for a rational trier of fact to find in the state's favor on that issue that the defendant did not act in self-defense beyond a reasonable doubt. I'll refer now to the facts. The defendant must actually and reasonably believe that he is acting in self-defense for any of the various forms of self-defense to come into play. He must actually believe it, and that belief must be reasonable. The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlyn. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, my plan all along was to turn myself in. He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, I acted in self-defense. At no point did he tell Sergeant McLaughlin, I did what I had to do. I didn't want to kill Caitlyn, but I had to do it. Words to that effect. At no point did he say the word kidnapping. At no point did he say anything indicating he thought Caitlyn was kidnapping the children. This kidnapping is a fabrication that the defense has presented here. The defendant himself did not believe it, and that's what the evidence shows, certainly in the light most favorable to the state. There is no evidence that the defendant believed it was necessary to use deadly force to defend himself or another. The defendant told Sergeant McLaughlin, when asked, that Caitlyn did not threaten him, did not threaten Ellen physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police, when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense, or acted in self-defense, or acted because he thought Caitlyn was going to steal his kids, or acted because he thought he was never going to see them again, or that he was necessary to prevent these things. The defendant called his mother and told his mother, in effect, I shot Caitlyn, you should probably call the police. He didn't tell his mother I had to do it. He didn't tell his mother she was going to kidnap the kids. He said, I shot Caitlyn, or words to that effect, we should probably call the cops. In the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner. I'll go through the various forms of kidnapping. I'll put this on the record, Your Honor. Under State versus Monroe, and I don't have the site handy. Here it is. 173, New Hampshire, 469. The defendant not only must provide an actual notice of defense.
He called his parents. His parents called the cops, and they found her. That's because he didn't even do it himself. And then he drove to another state, drove back again, and was spotted by a woman from Las Vegas who was visiting her daughter. It's a weird story.
Support of the defenses they intend to pursue, but there also has to be specific presentation of or sufficient notice of the factual allegations supporting the defenses. With regard to burglary and all those other flavors of kidnapping flavors of self-defense beyond kidnapping, I don't believe that was done. Walking through each of the varieties of kidnapping in 627-4, starting first with 2A, I address that. There is no evidence that the defendant acted because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B, the defense presented this court with a variety of crimes they claimed that Caitlyn could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duren's home. I can only imagine what the defense attorney would say if the state tried to charge someone in Caitlyn's position with burglary, based on the statements and the facts and the circumstances in this case. I'm not going to address each of those crimes. I don't think it's necessary. I don't think the facts support them, and certainly not in the light most favorable to the state at this stage. There is sufficient evidence to show that the defendant did not actually believe Caitlyn was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlyn was going to have a purpose to commit theft by deception or false imprisonment or anything along those lines. So at this stage, in the light most favorable to the state, there is not sufficient evidence here, or there's not a lack of evidence that would allow this court, on the state of the evidence as it is, to dismiss the murder charge because of the defense arguments. 2D, 627-4-2D, defense counsel misstated the law. Defense counsel stated that under 627-4-2D, well, I'll state, the law says that a person is justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor while inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlyn was likely to use unlawful force in the commission of a felony against him. Defense counsel clearly claimed that he was going to use force against, that Caitlyn was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that. And there's certainly not sufficient evidence that the state cannot defeat it and that there's that no juror could find for the state on this issue. With regard to kidnapping, I'm going to ask the court to reference the arguments that we made on pleading filed yesterday about the law. I can summarize them here. I don't want to get too far into the weeds, but to come back to the actual and reasonable belief, the court knows what the defendant said in that statement that was put into evidence. That is the evidence of what the defendant, at this point, actually believed happened inside that apartment. I'll note also that at this stage, credibility determinations with regard to witness testimony must weigh in favor of the state when they're equal. And the court can assess the credibility of the defendant's statements or different parts of the defendant's statements, taking into account that he is providing his account of what happened, his story of what he told the police about what happened. With regard to kidnapping, as we stated in our pleading, Ms. Naffziger legally could not kidnap her own child under 633(1)A. Could not do it. Based on the interplay of 633(1)A and 633(1) and 627(4)(2)C, as we state in our motion, interference with custody is not a basis for the use of deadly force. That is what the defense is arguing. The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlyn could do. And to find that would be to add interference with custody to the list, to the narrow circumscribed list of circumstances where the law allows the use of deadly force. And that should not be the case. And with regard to each of the different versions of kidnapping, at this stage, again, the defendant did not tell the police that he killed Caitlyn because she was holding Elowen hostage. There was a reference to his training. The sergeant asked the defendant about if he had any sort of hostage training, and the defendant, it was somewhat difficult to see what he said or understand if he was giving an affirmative answer. He may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly, that's what I thought this was. This was a hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal, that the defendant actually and reasonably believed there was.
Jen, don't start being a Brandon on us now. You had us worried yesterday, and now you're choking on. Don't do it, Jen.
It's a legit fear. I almost passed away with a Twizzler when I was walking down the stairs and it got lodged. I was eating it.
You don't run with scissors, and you don't eat while you're walking, Jamie.
I
Come
know. Well,
Isn't that called a George Bush joke? No, that was a pretzel. Choking on a pretzel.
happened more in my life.
And that is why he killed Caitlyn. And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlyn was committing a kidnapping in ignorance of the law, which says that what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are, he is mistaken on what a kidnapping is in the state of New Hampshire, that is not an excuse. The defense argument is built upon the idea that ignorance of the law is an excuse, and this court should not agree with that. 633.1.1a is the ransom hostage situation. I'm not going to address that any further. 633.1b says that there's a kidnapping if someone confines a person to avoid apprehension by law enforcement. There's no evidence that that's what was happening here, and defense has not claimed that. 1c, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlyn was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay. And 633.1.1d would require that the victim confined, or Caitlyn confined Elowen for the purpose of committing an offense against Elowen. That is not, there's no evidence that Caitlyn was intending to hurt Elowen. And in fact, the defendant disproved that. He said, yeah, she was not threatening to harm Elowen. As Sergeant McLaughlin testified, the defendant told him Elowen was yelling, but the defendant said it was a combination of things. It was not just because Ms. Naffziger was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond a reasonable doubt on knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or there is
What?
the state of the evidence at this point does not justify dismissing them on self-defense ground because there is sufficient evidence for the jury or the rational trier of fact to find in the state's favor on the self-defense issue. Moving to reckless conduct under 631.3, the elements of that are the defendant engaged in conduct that either placed or may have placed another person in danger of a serious bodily injury, and that he did so recklessly with a deadly weapon as a firearm. In this case, the defendant, by his own admission, grabbed Elowen and then fired a gun at Elowen's mother while holding her so close that she complained instantly that her ears hurt. Reckless conduct does not require actual injury. It does not require evidence of actual trauma or actual diagnosis of injury. In this case, we do in fact have the testimony of a doctor who said she sustained an injury to her ear. That was what the doctor said. The defendant used a deadly weapon, and that deadly weapon was a firearm. The defense argument focused
Whatever
on the
comes
fact
up.
that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms, and that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what they're saying the evidence shows, then Elowen is somewhere within the room, not in his arm.
The next thing I have in my calendar is next Wednesday, because Krusty is back in court next Wednesday. That's the next thing I have in my calendar. So, yeah. The state rested, and the defense wanted the direct verdict because he was just saving the kids from a kidnapping that didn't exist. It's taking a very long time today. It's a motion for direct verdict meant. That happens when the state rests, the defense will say, you didn't prove your case, and the judge will say, well, I have to look at it in the light most favorable to the state, denied. And I don't know why this guy is still talking. This is more annoying than, because the defense lawyer has to fight for this guy, and this guy is just yakking on. He knows that the state is going to say, yeah, it's not going to fly.
Fine, I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elowen, however, it's the risk of any injury, including injuries to the ear or to Elowen's hearing. There is testimony about that in the light most favorable to the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find the unreasonable doubt before the state. With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we're talking about injury to the welfare of a child, not physical injury. The cases on this crime that describe other versions of this, where people have been convicted and those convictions have been held, speak of situations involving a caretaker getting high or drunk with a child in the car. Certainly while driving, but in other instances just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Elowen's mother in front of her. Although he told the police that he didn't think she saw anything, he hoped she didn't. She told the doctor that mommy and daddy were fighting, daddy hurt mommy and me, and there was a lot of blood. In the light most favorable to the state, certainly it is clear that Elowen knows what happened. Elowen is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence sufficient at this stage that by shooting Caitlyn in the head, the defendant endangered Elowen's welfare. We are not claiming that he injured Elowen beyond by shooting her with a gun. But when we're talking about endangering the welfare of a child, psychological injury or psychological welfare comes into play, emotional welfare, and that is what we're talking about here. There does not have to be evidence that Elowen is actually in therapy or that she's actually been diagnosed with a mental health issue for it to be shown that the defendant endangered her welfare by doing things that he did. The dual standard here that the defense mentioned is the standard, purposely violating a duty and knowingly endangered the welfare. There's a case on that addresses it pretty well. That's cited in NK. That case, I think, discusses that standard in a good way. Also, State versus Wartner. I don't have the site, I just have the name, but BORTNER specifically discusses the interplay between knowing and purposeful. That is not a legal issue. And Wartner talks about a failure to act rather than an affirmative act. But
Cite on Warner?
excuse me,
You have a
I
cite?
don't have one. I
Okay.
apologize.
No.
I don't have it on me.
Thank you.
But BORTNER, it's 150 NH. I forgot to
Okay, no, thank you.
write down the end of it. Knowingly endanger and purposefully violate. I don't think that it is in dispute that by shooting Ellen's mother in the head in front of her, that the defendant purposely violated the duty of care. He had to know. Anyone in that situation would know that would
Can't use a
seriously
4-year-old as a
seriously
witness for anything.
danger to a child's welfare, psychologically and emotionally or otherwise. And purposeful violation of that duty of care that he owes her. I think the knowingly engage in conduct speaks to the act. And we have already argued that the defendant acted knowingly. I think that's all I see has at this point. We ask that the motion be denied.
Okay.
Denied.
Your Honor, 150 New Hampshire 504.
504, thank you. Okay, thank you. Thank you.
Just one comment, Your Honor. I think I said it in my motion, that the state didn't offer any evidence of psychological injury or trauma or anything. It's speculation based on what it feels like. There was no evidence. And I'll leave it at that.
Okay, thank you. In response to that?
No, I don't think it's a reasonable inference that shooting a child's mother in the head would endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State versus Wong, 138 New Hampshire 56, 1993, State versus Burke, 122 New Hampshire 565, 1982, and State versus Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss. With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony, referring to Mr. Duren, as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627-4, Roman numeral 2.
Hello, Mole Raiders, and welcome.
At this point in the proceeding, I would find, once again, at this point in the proceeding,
And
I
thank
would
you,
find
Mo,
that
for
there
the
has not been
raid.
evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, that no reasonable trier of fact could have found that the defendant did not act in self-defense if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to.
This is the direct to ask for a direct verdict. The state has just rested, then the defense is always asking for a direct verdict. He'll always deny it. It's only happened in one trial any law trooper has covered in the 3 years I've been a law trooper, crime trooper, true crimer, whatever. And it was one case Nick was following. Everyone else will be found in the light most favorable to the state. You will get convicted.
Double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that takes care of the instant motion that is before the court. Attorney Kinney,
Yes, yeah, I think so.
anything further?
No.
Okay. Attorney Spicer, anything further at this time? No? Okay.
Just bring the jury back in and get going.
I think he's indicating no as to that motion, Your Honor, but we do have an additional
Okay.
motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No, Your Honor.
Okay. Attorney Duren?
Mayor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumunden and/or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present, along with Ms. Plumunden, in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlyn Naffziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumunden would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlyn Naffziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently, based on some level of fairness argument or and cited to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumunden and Ms. Naffziger, and that supposedly that Ms. Plumunden will be testifying to that plan, but the court believed, based on its reading of the transcript and based on some level of a value of fairness, that Mr. Duren was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan and that he would need to have knowledge of such a plan, or at least of the desired results, in order for this information to be admissible. He would have to know that Ms. Plumunden was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant's saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said. And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material, But by its own ruling, the court has said Ms. Plumunden can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumunden and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Naffziger and for the support for these arguments that she was going to kidnap the children and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Naffziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Naffziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, and with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumunden with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Okay, thank you, Attorney Duren. Attorney Kittle?
Yes, Judge. I would reiterate all the arguments made in our objection, written objection, in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we've discussed at length previously, that Mr. Duren was aware of the plan. I'll note a couple of things. I think the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that, like a statement that was made to Ms. Plumunden about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumunden's testimony about a current plan, it does apply under 8033. I'll just note a couple additional things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Naffziger had this plan. Ms. Plumunden has told that to detectives to our investigator. She sent a text saying they need to help plan a kidnapping. And so
Hey, Stanley.
the state's going to argue that kidnapping is a fabrication of the defense. That's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but the state said the door has been opened because there's been evidence of Ms. Naffziger's aggression. The state introduced that statement. The state pressed play on a video that had a statement about Ms. Naffziger's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duren, any response?
No, Your Honor.
Okay. Satisfied with the record relative to those issues?
Yes, Your Honor.
Okay, all right. I'm going to deny the state's motion to reconsider on that aspect. I ruled several times on this matter. I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Oh, yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that.
Talk to her now and don't
Miss
do all the sidebars.
Brenda Plumondon is
Ah.
a witness. But Ms. Spurgeon,
Hey, Jacko.
Trooper Pratt, Arthur Booton are all here in case we need to call them for rebuttal purposes.
All right.
I do have a
my
request
camera just
before
didn't
Ms.
fuck up.
Plumondon comes in, Your Honor, but it's about her testimony.
Um,
But it's appropriate.
And I'm just
she was
going
wanting
over my
money
notes
from her or
relative to the
something.
state's-
I don't know. We don't really know what the state claims. They just claim he wasn't justified, and the defense claims that he had to do it because she was either blackmailing him or kidnapping his children or making burglary at his house or I don't understand the defense.
Yeah.
Can we just get going? Get to the defense part. Get the neighbor in or the friend in and say, yeah, she was going to kidnap the
Okay,
kids.
again, I'm going to restate part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duren through Sergeant McLaughlin, it is clear that at several points in that statement, Mr. Duren referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time, after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Naffziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? There was a number of times in which Mr. Duren was asking what was happening.
No, I don't hate sidebars, but in this trial, they have had a sidebar. Every time the defense goes to ask a question, they call a sidebar. And then they spend 15 minutes arguing and go down and say, so do you tie your shoes? No further questions, Your Honor.
To Ms. Naffziger, according to his version of events. And based upon the defense
they're bad
argument
lawyers.
relative to the introduction of Ms. Plumond, am I pronouncing it correctly? Plumondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Naffziger, and not with respect to the reasons for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court, and I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Duran, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plumondon is here. Well, I believe she is. I haven't seen her today, but, okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that something might be said to cause a mistrial.
Well, then don't call
I'm
her.
asking for two things. Number one, for the court to have a
I
colloquy with
hope there
her
is
outside the
chaos.
presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a desire, a natural desire to try to explain things. And I would like to be able to lead a very tight and specific questions to produce the testimony that you have deemed to be admissible. I will note that the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plumondon for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plumondon is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plumondon because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her. And now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered. But that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern, and I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form.
The lady they want to call is the aunt of the deceased, who she allegedly had discussed removing the kid from the house, and I think that's the person he wanted to drive her down to. Yeah, she's going to be a hostile witness. Of course she is.
Yeah, she was involved in all of this. Like, she's obviously gonna be ticked
Yeah,
off.
she's not going to go in there and say, yeah, she was planning, and we told him all about it, and that's why he blew her head off. She's probably going to go in there and be really, really mad at him.
Defense wanted to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions. There's no indication that Ms. Plumondon is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her, but the consideration.
If I may interrupt really quickly, the Zwicker letter says Ms. Plumondon was asked 2 questions and provided the answers to those 2 specific questions, and that is it.
Okay, so you talked to her, though.
2 questions. What was Valen's date of birth? I do not know. Was Caitlyn Naffziger breastfeeding? No. Those were the questions.
611-2, C2.
That's what I'm looking at.
Okay. When a party calls a hostile witness an adverse party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Plumondon about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I've not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very.
I would be stating a riot in the jury room right now. I'll be burning the wastebasket. They went in for 5 questions, for 5 minutes, and they have been out for over an hour now.
Very
God.
prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So for that, there's 2 reasons that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
Okay. Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duren, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay, all right, thank you. Okay, I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been subpoenaed, number one, that she has been subpoenaed here, and that she's going to be asked questions, and that she's instructed to, is she prepared to answer the question that she is asked? Are you prepared to answer the question that you are asked? And are you prepared to limit your testimony to the question that was asked and not to volunteer further information? That's sufficient, Attorney Kenny?
And Your Honor, I think it would also make sense to instruct her specifically in accordance with your order that we're talking about the what of the plan and not the why of the plan.
And finally, that she's not to testify about statements allegedly made by Caitlyn. That she can testify as to her perception, her understanding of what her understanding.
Just a question for clarification, and it's why the state has asked so many times for the motion to be reconsidered. Is Ms. Plumondon then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Naffziger, or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Naffziger?
And I've already ruled that relates to her understanding as to that, not relative to indirect hearsay. But she can't testify as to what Caitlyn said to her, but she can testify as to what she understood the plan to be. Anything further, Attorney Keenan?
No, Your Honor.
Okay. Attorney Duren, anything further right now?
No, Your Honor.
Okay. 10-minute break?
Thank you.
Okay.
I swear.
So now we're gonna get one witness on, and that's gonna end in a shitstorm because she's gonna say that, and then the defense is gonna claim, "Hey, give us toss the case because she said all the things that we said she wasn't allowed to say," and then we are gonna have to argue that. Jamie, do you know Marissa told us all that we should be joyful they would get the case and start verdict watching at midday today? I have it from Marissa's own mouth. I had the comment where she said it pinned, but then AJ's daughter asked me if I could maybe help promote her getting some better equipment for her new police job for the state of Texas. Please consider if you might be so inclined to help a friend of the channel, Carmen, get some better body armor and equipment for her new police job. It's a bit of a sad thing that they have to make themselves secure. But please, if you can, there is a link for her. Buy me a coffee. That's what it's called. Buy me a coffee, and if you are so inclined, please, if you're considering super chats, why would you? But if you're considering super chats, it would be very appreciated if you considered Carmen instead, because I'm just an idiot with a camera. She's actually out there fighting crime.
That's crazy that they would make them have to do that.
Yes.
So support Carmen.
Yeah, please do that. And if you are just getting in here, today is also one of my favorite people's birthday. Jamie doesn't like her, but I think she's wonderful. She's always right. She is one of the best people I've had in my chat. She's almost been here from the beginning, if not from the beginning. Jamie despises her. Something about her support for the Gamecocks, which I find is weird. Jamie, just because the Ohio Buckeyes are a better team, you don't have to hate others. So help us wish Sue a happy birthday. She's turning 23 years old today. Imagine that, 23. Remember when you turned 20? Well, Jamie's turning 23 later this year. But imagine back when you were 23. And Sue is getting to that point now with a lot of online hate from Jamie, but not from me. I am always supportive of Sue.
You're such a shit starter. Happy birthday, Sue. I love you.
I'm not a shit starter, Jamie.
Yes, you are.
Why? Oh, you can't say the truth. You know, I only have one rule on this channel. Shit.
Always starting. Yeah,
That's me.
please. It should say all the drama.
I'm thinking making a new merch line, because then I can wear it whenever I'm talking drama.
I know.
I am
I-
always supportive. Thank you, Sue, for noticing.
He is
I'm
the
one of
drama
those.
king.
I'm just one of those nice people.
Of course, you're a nice guy. You just love drama. Who doesn't? We all like it in our little way. It's entertaining.
No, Jason, I didn't say you had any legal obligation. I said if you was considering it. Sometimes, even if it's cops, you can be nice to them. It's absolutely fine. Especially Carmen. Carmen is a sweetheart. I would rate her maybe as high as I rate Sue. She has been very friendly with us and been nice to us, and her mom is doing a great job over on their channel. Everyone should go sub to that channel. It's a great afternoon show. Sadly, Jamie can't watch it because it starts at 6 p.m. Jamie is in bed at that time.
Always asleep.
But that's why we like to support friends on this channel. And if someone is that inclined to do a little something for someone else today, please consider it to be Carmen.
Yeah.
Am I 757 Virginia? What?
What?
Is it me broken? Is someone else broken?
I don't know.
I don't know.
These names, I don't.
Yeah, I hate these names. See, Sue loves Carmen. She didn't like Jamie. Just saying. Jamie, you know I'm a truth teller. I'll cover nothing.
Mm-hmm. You speak your truth.
Oh, it's brokenhearted. I thought, what the hell had I to do with Virginia? I never been in one.
What? Where'd you go? What happened? I don't understand.
Sorry.
What happened?
I made a joke, Jamie. Don't go back and listen to it.
What did you say?
Nothing, Jamie. Stop
I was-
asking.
How was I right here and I didn't even hear it?
Sometimes you should listen to the show. We do make some jokes sometimes when we're a little bit bored.
Oh my God.
Oh, the tall lady is back. No, I didn't fart. I just made a joke that I felt was so naughty that I had to go off screen and laugh a bit.
Did you fart? Oh Lord.
Why is people? I mute myself when I'm farting. I'm that professional.
You do not just sit there and mute yourself so you can toot.
Should I toot with the microphone on?
I really wish you would. Just for kicks. Just for kicks for us.
Yeah. When we're sitting here getting bored, I'm just.
If I ever heard that, I'd lose it.
Don't. Oh yeah, Ginger thought I was rubbing one out yesterday.
On screen? Like, what was he doing?
I was off screen, and I was because they were so you could read the text because the audio was so bad. And then Holly asked me not to put up chats on the screen, so I was just sitting and typing in chat. And then, of course, Ginger, because she is a little bit of a, I'm gonna say it. She's a maniac on the floor. She started thinking I was pleasuring myself.
Oh my Lord.
These are the people you attract, Jamie.
I didn't attract anyone. I'm just here for the ride. Look who shows up when you're talking about farting.
Yeah, Valhalla.
Aw.
Yeah. And he's gonna pretend that he has never ever sat on a stream and thought,
Stop it.
no tacos before stream.
Jeez, oh Pete.
I'm not breaking. But I didn't have that one on.
I think what would be funnier is if he thought he muted and he forgot to, and then that one rip. That would be my favorite.
Yeah. Yeah, it's just to get the you know the last little bit of it out.
Okay, stop it.
Jamie, did you know it's really unhealthy not to fart?
I've never really researched this, so are you gonna explode if you don't?
What the hell?
What? Piss shivers.
Yes, I did. No, it runs on the. I don't know how it looks. I don't watch on TV, so I don't know. Sorry. Headed to herd cattle in Idaho with the real cowboys. Danny T, take care of them cowboys.
Bye. Have fun.
The little chill when you're done peeing. I don't think I have that.
that what happens?
Not in this man's world.
Not in this man's world.
Maybe I should just do that. Roll back and toot into a
Oh my
lighter.
Lord. No! This has gotten out of control.
I didn't start the fire, Jamie. I was always fighting since the first beginning. I didn't fight the fire. But it's always growing and you have to show it.
I've created a monster.
I'll tell you, don't think there's a different tingle you can feel, but that's post tingling if you shake it a little too vigorously.
What
I'm
does
just
that
saying.
mean?
Jamie, I'll tell you when you're old enough to learn about it. Oh yeah, that's stupid. That's not how. I can't remove that on the side. That's how YouTube does it. I can only the ones I pull up in the bottom. I'm talking to Holly because she sent me a screenshot. The
Oh,
one on the right, I can't do anything about. She has Christmas decorations out, Jamie. You would love it.
you can't until Halloween is over. I mean, the second Halloween's over, midnight hits. It's Christmas score.
Farts makes everyone laugh.
I mean, I just in general, they're funny because most of the time that people that do them that I'm around, like it's an accident, and it's the funniest thing when it's an accident because they get all crazy, like, oh, it's like, oh my God. That's what I find funny.
I was at the gym the other day, and our hack squat machine is just you're standing here, and right in front of you, you have your leg press, and there was these two younger women who were doing leg press, and one of them went a little deep and got a little pressure on her tummy, and I was just about changing my the number I was listening to on my headset, so there was silence, and I just heard the and I thought, no, you just pretend that you had your music on so you didn't hear it, because she was red as a beet. And
I would have fell over laughing.
Katie, it's AJ's daughter, Carmen. She has changed from working for the federal police to the state police. So if anyone is so inclined and might consider donating a little bit of money to this channel today, please don't. Please go over to Buy Me a Coffee and contribute so she can get some better safety gear, because she is only getting the basics. And she asked me, she's very, very kind. She said, "Oh, you don't have to do it." And no, I know. And I'm sorry I asked it. She's always very nice. She writes me at 7 in the morning when I'm sleeping. I don't like that, but hey. But
Don't
if
forget.
you could potentially help me. And I said, sure, I will. And Hellfish is also trying to reach out and try and help with some gear. So it's to help her be safe when she's working, because we like AJ, we like Carmen, we don't like Gabby.
Please be seated.
I love Gabby.
Gabby is just as mean as you are.
Well, we're two peas in a pod.
Yeah. Now I'll take a pee break. No, I'm not farting.
Okay, we're back on the record outside the presence of the jury. Good morning, Ms. Plumondon. Am I pronouncing that correctly?
Yes.
First thing, Ms. Plumondon, if I could have you raise your right hand, please. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes.
Okay, thank you. Can I ask you to please spell your last name for the record, please?
Plamondon.
Thank you. Again, thank you for being here. I understand it's under subpoena. Have you spoken with Attorney Kinney about the scope of your testimony?
No.
Okay. Ms. Plamondon, I am allowing the defense attorney to call you as a witness in this matter, but I've placed significant limits on the scope of your testimony. Okay? And has anybody told you that?
The defense attorneys just let me know that a minute ago.
Okay, all right. I'm going to go over that with you now in an effort to just make sure that we're on the same page before the jury comes back in.
Okay.
Okay, thank you. When Attorney Kinney, the lawyer for the defendant, when Attorney Kinney asks you a question, are you prepared to answer the question that was asked by Attorney Kinney?
Yes.
Okay. And when you answer her questions, are you prepared, when testifying, to not volunteer further information other than what you were asked about?
Yes.
Okay, thank you. Now, I want to also let you know that the state will have the opportunity, when Attorney Kinney is done, the attorneys for the state will have the opportunity to ask you questions as well. So that may clarify some of what you are asked by Attorney Kinney, but they will be operating under the same orders and rules that I have put in place relative to what they can and can't ask you. So it's not just Attorney Kinney asking you questions. The state will have the right to ask you questions as well. Okay?
Okay.
Okay. And Ms. Plamondon, the questions are going to be based upon what you knew at certain points in time. Okay? They're not going to be based on why you knew them. In other words, it's not based upon what Caitlyn told you or why certain things were being done. It is limited to what you knew at the time.
Okay.
Okay, in other words, your knowledge as to what was happening at certain points in time. That is what your anticipated testimony will be, at least with respect to the questions being asked by Attorney Kinney.
Okay.
Okay? Specifically, it will be about what you understood, your personal understanding as to any plan that you might have had with Caitlyn.
Okay.
Okay? It doesn't include Caitlyn's specific statements to you as much as it is what you understood the plan to be.
Okay.
Okay? In other words, it's limited to your understanding at certain points in time. And I understand it's difficult on many levels. I'm simply going over what the court's expectations are at this time. Do you have any questions of me, ma'am?
No, I understand.
Okay. And at this point, Attorney Kinney, any further comments or inquiry by the court that you would request?
No, none, Your Honor.
Okay. Any from the state at this time, Attorney Duren?
Nothing.
Okay. So I'm going to bring the jury in, and once again, if you have any questions of me, I realize this is a difficult process. If you have any questions of me, we can try to go over them now. I'll give you just a moment.
If there's a word or something that doesn't fit, is it just a no answer then?
Just answer honestly. Answer honestly. Answer the question that Attorney Kinney or the attorneys from the state ask you. Just answer honestly to the best of your ability and to the best of your understanding as to what you understood at the time relative to any plan with Caitlyn.
Okay.
Okay? I appreciate your ability to follow the court's instructions. Okay? Thank you.
Yes.
Anything further? Okay.
Hopefully this is chaos. Just for us to all get some spice in our life this morning.
Again, from the jury's presence.
Sure.
Thank you.
It'll probably be super boring in this case.
All rise for the honorable jury. County Superior Court is now in session. The Honorable Jonathan S. Frizzell presiding.
Okay, thank you. Please be seated. Ms. Plumonna, if I could have you raise your right hand. Do you swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
Okay, if I could have you state your name, please, and spell your last name for the record.
Brenda Plamondon, Plamondon.
Thank you.
Good morning, Ms. London. I just have a few questions for you. You live in New Hampshire?
Yes,
This is the aunt who apparently had some kind of deal with her to get the kids.
And you have 2 children?
3.
3 children. And Caitlyn Naffziger was your niece by marriage?
Yes,
Okay. And Ellen and Valen are her daughters?
yes,
They never lived with you though, correct?
no,
In early of 2024, Caitlyn reached out to you about coming to visit?
yes,
And she didn't give you much detail about her visit at that point, right?
yes.
So yes, she did not give you detail?
She did not give me much detail.
Okay, thank you. And in later February, she reached out again with information that she was going to come to New Hampshire?
Yes,
Okay. And you knew that she had a plane ticket to Boston, correct?
yes,
And that she was bringing the baby Valen with her, correct?
yes,
But you didn't know where she was going to stay, right? Before she got to Boston?
yes, that's true.
Okay. Or if she needed to borrow a car, right?
Right, I had offered.
You had offered, but you weren't sure. She never responded yes or no, right?
True,
Okay. But Caitlyn and Valen did come to Boston in late February 2024, correct?
yes,
And they stayed with you the first night they arrived
yes,
in Hampton?
yes,
Okay. And you and Caitlyn and Valen stayed the night in Hampton. Was anyone else there?
yes,
Is that Shannon
yes, and my husband, Mark.
and your husband, Mark? Shannon is your friend?
Yes,
So that night at your home was the first time you really got to talk to Caitlyn about her visit to New Hampshire, correct?
yes,
Okay. And that Caitlyn was there, her plan was to go up and get Elowen and go back with both kids to Minnesota, correct?
yes,
Okay. And so you and Shannon and Caitlyn talked about how that plan would play out, correct?
yes,
Okay. And you knew that Caitlyn had a return ticket to Minnesota, correct?
yes,
And you would offer to pay for Elowen's ticket back?
yes,
Okay. So the plan was that Caitlyn and Vela would go up to Dustin's in Berlin and study his habits, right?
Objection.
no. Sorry.
Approach Honor.
They were allowed to lead her, I believe. That's why she's asking these very, very specific questions. So she won't say something that can potentially cause a mistrial, because this aunt is, of course, biased against the defendant. Yes, like the Lulu said, they are leading because she's a hostile witness. And I don't think this is going to end the way they believe. And for the poll, 89% believes guilty. 11% says not guilty. 134 votes. Well, she was instructed by the judge, and someone probably told her, hey, this can cause a mistrial, so better behave, and then he'll get convicted.
So, Ms. London, the plan was for you, if you had not heard from Caitlyn on Saturday, you were going to go to Berlin and wait at a restaurant to leave with her and the kids, correct?
No.
You spoke to the police back in March of 2024 about this case, correct?
Yes.
Okay, and that was a recorded phone call that you gave them?
Yes.
And you agreed to be recorded?
Yes.
And you told them everything that you knew at the time, correct?
Yes.
And you didn't leave anything out?
To the best of my knowledge.
Okay. And you had a chance to look at the transcript of that recording, correct?
Yes.
Okay. And I'm going to show you page 7 of your transcript. Where you say line 9.
I assume it's being used to refresh your recollection.
I'm impeaching her, Your Honor.
Okay.
Objection.
From-
Oh. Wonder why they had called her set up the kidnapping story, I guess. Yeah, it's to say that this was pre-planned and she wanted to take the kids away, and somehow he had some knowledge of it, is what I gathered from what they were saying beforehand. But how would he have knowledge of it if they never told him? And that's what the state's argument was. He didn't know anything. He never ever stated anything in his interview that, well, I knew that her and her aunt was going to kidnap the kids. So where's the prior knowledge of her plans that made him do it? Did you see the defense face? She was pissed. Yeah, she wasn't happy. See, this is one of those. I know the picture, but that's not the name. Well, you missed a lot of arguing. They spent an hour arguing after we had a witness on the stand for 5 minutes. And now we have the aunt. This is the first defense witness, and they have had 2 sidebars in 5 minutes. She's been treated as a hostile witness. When you're treating them as a hostile witness, it's kind of the same as you were on cross-examination with her. So you are allowed to lead and you are allowed to impeach, because she is not technically, but she would be seen as a state witness. That was the same, remember, during the Karen Reed trial, where they talked about potentially calling Michael Proctor, and there was a lot of talk about if he was called, would he then be treated as a hostile witness? Because then you can lead, then you can impeach him, you can do all of that stuff. And that's what they're doing with this one, because she is the deceased aunt, and she's probably not wanting to help this guy out. All of this is so wasteful. Yeah, Robertson. Or D. Robertson. Yeah. I knew something was off. Yeah, your side eyes. Cardi B was a legit hostile witness when she was called by the plaintiff. Of course, because she was the defendant in the case.
Ms. Lamondan, when you, did you, you were able to review the transcript of your interview?
Yes,
Okay, and was it a fair, and does it look like this? Does the copy that you were given look like this?
What is this defense exhibit, what?
ID,
D.
D.
Thank you.
I don't know, it was an email.
Okay, well, why don't you take a look at that and let me know if that looks like item you reviewed.
Yes,
And is that a fair and accurate transcript of what you told the troopers in March of 2015, March 15, 2024?
some of it was mislabeled of what Shannon said and what I said.
Okay. And so I also have clips. Were you able to listen to the video?
No.
Okay. So, Your Honor, can we approach?
Yes.
You just went up there.
Oh my God, they suck.
This is the fourth sidebar with their first witness. This is going to take forever, Jamie. And Marissa said this will be in the hand of the jury by noon. I'm not sure Marissa is telling the truth. I think she's pulling our leg.
Who's? I don't know about.
I think she is, Jamie. Don't always protect her because this. I won't abide by this.
Oh my God. I won't abide by this.
See, now she comes clean. That's. Yeah, he should do that. Transcripts are reliable when it suits the defense.
Okay, Ms. Clement, please review page 7, line 7 to 18, and then I'll ask you questions again of ID, defendant's ID, Exhibit D.
Okay.
May.
I think the defendant needs to testify.
So, again, that the plan was to go to Berlin and wait for Caitlyn and the girls to come meet you at a restaurant or somewhere and take them back to the airport.
No.
Okay, so can you tell us what the plan was?
That we were waiting for Caitlyn to call us and tell us how she needed a ride and that we would meet her wherever we needed to meet her. And if by Saturday we hadn't heard from her, that we were just going to go to Berlin and wait to hear from her so that we would be closer and ready.
And the plan was to get them back to Minnesota, all three, Caitlin, Valen, and Elowen, as quickly as possible.
Yes.
The next day, after that plan was discussed, you offered to drive Caitlin and Valen up to meet Dustin, correct?
Kind of.
Okay. Did you drive her up to Ossipee?
Yes.
Okay. And you drove with Shannon, Caitlin, and Valen, correct?
Yes.
Okay. And you drove Caitlin and Valen to the designated meeting place, which was a restaurant in Ossipee, correct?
Yes.
Okay. And Caitlin brought a suitcase with her, correct?
Yes.
She had a bag of like wet laundry because there was an issue with the dryer.
Yes.
Okay. But she did leave behind other things, right? Like her backpack,
Yes.
kids' birth certificates.
Yes.
Would you like a break?
They were staying with the dad, as far as I know. That's the deal they had. They were going. If he paid for the tickets, she was gonna bring them to his house.
Okay.
Okay. I only have a few more questions. You didn't see Dustin or Ellen when you dropped Caitlin Valen off, right?
No.
And after you dropped them off, you called Caitlin's mom to tell her what the plan was, right?
No.
Okay, you called folks though to talk to them?
Yes.
Okay. Those folks being her mom
Yes.
and her dad, Rob?
Yes.
Okay. I don't have any more questions, thank you.
Why the hell did you call her?
Horse indulgence.
I think they want, it's still unclear because it's like they wanted to get the plan out there. That this was all their plan, but he didn't really know about the plan. So what? So what does that have to do with anything?
You're welcome, sir. Okay,
Yep.
there's some water there. Do you have some?
Yep.
Okay, do you need to take a minute?
Nope, I'm okay.
Okay. Ms. Plumondon, you live in Hampton, New Hampshire, correct?
Yes.
How long of a drive did you have to come to court?
I don't know, like 2.5 hours, I think?
Are you familiar with this part of the state?
No, I'm not.
Had you ever been to Berlin, New Hampshire before?
No,
Have you still to this day been to Berlin, New Hampshire?
I have not.
Now, Caitlyn Naffziger, she flew from Minnesota to Boston on February 27th of 2024, right?
Yes.
And then she took a bus to New Hampshire?
Yes.
And then you and/or Shannon picked her up from the bus stop?
Yes.
She and Valen, her youngest child, they spent one night with you in Hampton, correct?
Yes.
Can you tell us during that time, did you have a chance to observe Caitlyn and Valen together?
Yes.
Look, we're here without telling us what anyone said. What were your observations of their relationship?
What a good mom she was, and how relaxed the relationship was, and just how happy she was. Both of them.
Had Caitlyn ever come to see you in New Hampshire before?
Yes,
How many times?
at least
Thank you.
3,
Let me find
maybe
it.
more.
How long had it been since the last time she'd been here?
We have a holiday called Thanksmas, and she...
Thanksmas?
Yes, and we
Okay.
do everything that we've always done, Christmas to Thanksgiving in 1 week, and all the family gets together. And so she was there for that, as was her mom and husband and other family members.
Her mom's husband?
Yeah, her mom Lori and,
Okay. Just making sure I know
yep,
who you're
yep,
talking about.
and Lori's husband Tim and my kids, and
Had Caitlyn ever been to Berlin, New Hampshire?
no,
Not before February of 2024?
no.
This is a case where either he plucked her in the head with a 9mm because she wanted to take the kids away from him, or they had a custody battle, or he was protecting the kids from being kidnapped, burglarized, and hurt. So it's self-defense of others.
Did she have any friends in New Hampshire?
No?
Were you her only relative in New Hampshire?
Yes,
Besides your husband as well, right?
yes, yes.
And your kids?
Yep,
And you, and I don't mean this to sound improper, but you're related to Caitlyn by marriage, correct?
yes.
Now, on February 28th, so the very next day, I mean, Caitlyn was in your house for, when did she get there on the 27th? In the morning? Or was it nighttime?
It was evening, and I was working and coming from Boston, so I didn't see her until like 5 p.m.
Okay. So at some point, sounds like less than about, I don't know, less than a day later, you drove Caitlyn to that restaurant in Ossipee, New Hampshire, correct?
Yes,
A place called Harley Jack's?
yes,
Does it take, fair to say it took you over an hour to get there?
yes.
Had you ever heard of it before?
No,
Ever been there?
no,
When you got to Ossipee at Harley Jack's restaurant, Caitlyn got out of the car?
yes,
She took Valen out of the car?
yes.
Was Valen in a car seat?
Yes, it was like a car seat that fits into the stroller.
One of those like dual, like
Right.
pop it in and out things.
Right, but
Okay.
she left the stroller portion at my house.
Okay. You didn't go inside the restaurant, right?
No,
When Caitlyn got out of your car and took Valen, without telling us what she said or did what she said, how was she behaving?
I mean, it was quite a sad sight, and Shannon and I both cried. You know, she's such a small person, and she had this big, enormous suitcase, and you know, she had the baby in the car seat, and she was just like lugging it. I felt awful for leaving her there.
But you did leave.
Yes, she specifically asked that we not come in because
Objection.
So you left.
yes,
Okay. You didn't see the defendant at Harley Jack's?
no,
And just so we're clear, do you know the defendant?
yes.
How do you know him?
We have FaceTimed many times, and I, know him as the father of Phelan and Elowen, and
Okay.
because of Caitlyn's relationship with him.
You didn't talk to the defendant when when Caitlyn was in New Hampshire, correct?
No,
You didn't talk to him in Ossipee in the parking lot?
no,
You didn't talk to him over the phone after you left Caitlyn in the parking lot?
I don't even have his contact information.
Okay. He didn't speak to you?
No,
Did you leave before Caitlyn went in, or did you watch her go in?
we left we parked far away in the parking lot and left as she was walking through the parking lot.
So you didn't wait in the parking lot until they finished lunch and left the restaurant, did you?
No, I had no
Yes.
contact after she got out of the car.
And when you left the parking lot at Harley Jack's, where'd you go?
Home,
Okay, so you drove the hour back to Hampton?
yes.
You didn't follow them back to Berlin?
No, I was working and it was 5 o'clock, so I specifically, Shannon had driven up there, but now I was done working and I shut my laptop and I'm like, oh, I can drive home. And she's like, great, because I don't see well at night. So,
So you wanted to get home?
yeah,
You'd agree that your home is at least 2.5 hours away from Berlin?
yes,
Yes. And they didn't get anything about plotting
Now,
anything out of her.
What defense has asked you about in terms of this plan is that you were going to, the plan was for
Thank
you
you,
to go
Tracy
up
Dane, for becoming a
and sit at
YouTube
the
member.
restaurant on Saturday, correct?
if we hadn't heard from her at that point.
Okay. Did there ever come a time that you heard from Caitlyn?
No,
When you dropped her off in the restaurant parking lot, was that the last time you saw her?
yes,
As part of the plan, did you choose a safe word?
yes,
What was the safe
Kumquat.
word?
Kumquat.
that,
Your Honor, can we approach?
I want to know what it is.
If it's not kumquat, it's the wrong safe word. And that's why the plan didn't work, because the safe word is always kumquat.
What is a kumquat?
That seems weird. If they're worried about her, why leave her there? Why not keep in contact? Well, apparently they had a safe word so she can contact her and do it. Why is it blinking all of a sudden?
I don't know.
But I don't. Is this helping the defense, calling this witness?
I don't think so.
And they talked about maybe calling someone for rebuttal of this witness. I don't understand how that's going to happen.
A code word, correct?
I don't recall.
And if you got this code word, you were gonna drive 2.5 hours? Is that fair to say?
And call 911.
Was part of this plan to tell the defendant about it? Would that have made sense to you?
About
tell
the
him?
code word?
Nope, to tell him about the plan in general.
No,
Was Caitlyn gonna tell him about it?
It makes sense when she said, and call 911. That kind of makes sense.
no,
Was your plan designed to hurt Elowen?
no,
Was your plan designed to harm either child?
no,
Was any part of the plan to seek money?
no,
Was there any part of the plan that had Caitlyn telling the defendant that she was gonna call the police to take custody of the children?
no,
Was there any part of this plan that required Caitlyn to tell the defendant that she was gonna take the children back to Minnesota?
no,
Did Caitlyn have a car with her?
nope,
Did she have a rental car reservation anywhere?
no,
Did she have a bus ticket?
no,
Was Caitlyn familiar in any way with the area in Berlin, New Hampshire?
no,
And the plan was that she would have the 2 children with her, correct?
yes,
Caitlyn never texted you to say that she got into the restaurant okay?
no,
She never texted you to say the defendant was there?
no. She specifically said she couldn't text because he would control her phone.
She didn't call you to say that they were leaving the restaurant?
No,
Did she send you any?
Approach.
Lord. Lord. Hi, Tammy. Kimmy.
Yeah, I know why they want her there, but I'm just not feeling it's working to get that impression over because, again, why did he shoot her? It wasn't because he was about to take the kids. Well, maybe that's what they're going to argue in the closing, but that's not what they argued in the open. In the open, it was because she was hurting the daughters. It wasn't because she was stealing the daughters.
Yeah.
It's absolutely ridiculous, the amount of sidebars. Especially because they'll come back and, like before, it's not a safe word, it's a code word. Yeah, that's going to prejudice you a whole lot instead of just, yeah, and I pulled a pistol and shot her in the face.
Answer relative to controlling the phone, and I instruct you to give it no weight whatsoever.
What?
She didn't call you to say that they left the restaurant, correct?
No, she did not.
Did she send you any photographs of her with the 2 children at his apartment?
No,
Did she text you at any time and say, help, please come?
no,
Did she ever text you a code word?
no,
Did there ever come a time that you heard from Caitlyn after you dropped her in that parking lot in Ossipee?
nope,
Was that part of the plan?
no.
And no other questions.
Ms. Plumbon, part of the plan was for Caitlyn to take both children while Dustin was asleep, correct?
No,
That, you didn't discuss how he plays video games, it stays up all night?
Objection, you're not outside the scope.
Approach, Your Honor.
Oh, dang it. But why wouldn't you check on her? Well, maybe they had a deal, just as she said, she couldn't communicate because Justin would control her phone. Who knows? Is that really the biggest problem, that this lady wasn't calling her every 5 minutes saying, hey, are you okay? Are you okay, Annie? Annie, are you okay? Are you okay,
Yeah.
Annie? Again, it's not her job to keep the other one safe. She had a deal with her. You're going to call us if you need us. Yes, I am. Same deal I had with my kids. When you're out drinking and something happens and you need me, you call me. I didn't call them and say, oh, are you drinking tonight? Yeah. Okay. Are you safe? Yeah. Okay, I'll call you again in 10 minutes. It's burden shifting. It's not their job to keep her safe. They had a deal. You're gonna call us if you need us. So I can't see what the big problem is.
Well, and if she was adamant about like, don't call me.
Yeah, maybe
Or
she
no.
said, I don't want you to call because he might figure. Again, she could be trying to kidnap her kids and go to Bumfuckistan with them. Happened
Mhm.
before. Doesn't give him the right to shoot her in the face unless she was actively trying to kidnap them. She was actively trying to keep them at the house while he was trying to leave. So I don't know where the it's the worst kidnapping I've ever heard about. How was your Richard Simmons workout? It was absolutely great. I did all 50 minutes today. I kept going, and I sweated like a pig, but I kept it going all the way through. I've had some tendon issues the last couple of times, but today I got all the way through, and it was good.
Well, yay.
She plays some shitty music in the middle, but other than that, it was good.
What kind of music? I mean, what music do they normally play?
Well, it's called retro dance, so it's sold as something like, like 70s and 80s music, Madonna and YMCA and stuff like that. But I don't know what's wrong with these instructors. They always, we're going to put in some Latin music and dance Latin style. No, I'm here to dance retro style. I'm not here to. I can do Zumba if I want to dance Latin style. So I might have voiced that once or twice, and then I'm only putting 3 numbers in. Yeah, and we do like 12 routines. That's a quarter. That's Latin. Do Zumba if you like that. No, but I like Pitbull. Yeah, but I don't.
Like Mr. Worldwide.
I don't like Mr. Worldwide.
Iris would be so sad.
Well, I don't go running because I'm not a fairy. I listen to rock music when I lift heavy weights.
Oh my God.
And then I go dancing with the ladies on a Friday. Running is only if you're being chased. It's not good for your knees. It's not good for your back. Again, I don't see the problem. You're going to be with your kids and your husband. He's probably not going to shoot you in the face. You call us if you need us. I think that's an absolutely reasonable thing to have, and then sit at home and have a cup of coffee, have the phone open if she needs us. We'll call 911 and we'll race up there. Because you don't know if they might. We just watched another trial where apparently the monster came out and she still banged him. It happens a lot of times where there's a lot of angry words said, and then they get back together and, oh, yeah, well, I might have been a little too hostile, and maybe if we put the kids to bed and have a bottle of red wine and try and see if we can still do the horizontal mamba, maybe that'll fix it. It won't, but it happens in a lot of cases. I just don't get why she needed to be in a van outside the house. I wouldn't do it, but hey, maybe that's just me.
I think parts of her testimony, as in like, I don't know, like how she's just trying to be like, oh no, we weren't doing that. I mean, don't get me wrong. I believe they were probably a little more in depth with their plan, and she's probably letting on. But
and it's also,
I didn't think she had any reason to think the guy was gonna offer.
No, and again, she's a hostile witness. Of course, she's not going to sit there and say, "Oh yeah, that's I'm absolutely yeah. We planned everything. I had the tinted window van outside, and we were going to chuck the kids in the back and just race for the state line." I get that part.
Yeah.
Because of course she's a hostile witness. She's
Okay,
gonna
members
lie.
of the jury, the last question and answer I am striking from the
Timmy.
record, and I am indicating that you should give it no weight whatsoever as
I-
part of your
I can't
overall
remember the last
considerations,
question.
and you may rephrase.
Thank you.
Yeah, I don't remember what it was
Ms.
either.
London, is it fair to say that the plan was for Caitlyn to get the girls from the apartment and leave without Dustin knowing?
Yes.
Thank you. No more questions.
But Dustin
Did he
didn't
know about that? No.
No.
Of course she's not being truthful. She's a hostile witness. Of course she's going to lie. She's trying to help.
Mm-hmm.
It's the least surprised I've been all day.
Ms. Plumende? You've just testified that the plan was for Caitlyn to leave with the two girls, correct?
Yes.
Without the defendant knowing.
Yes.
Caitlyn did not have a car,
Right.
did not have a bus ticket,
Right.
did not know the area.
Right.
You were 2.5 hours away.
Yes.
She didn't know anyone else in the state.
No.
It was February in Berlin, New Hampshire.
Yes.
Fair to say the temperatures range between -2 and 32?
Yes.
Fair to say that it was snowing that week?
This is beyond the scope.
Overruled. I don't recall.
Okay. no further questions.
Okay, counsel approach, please.
Are we going to do the lunch break early, or are we going to get the next witness and go late? That's probably what he's calling them there for now. Are we going to get early lunch or late lunch, Jamie? 50-50. What do you think?
I mean, it sounds like he's trying to do an early lunch, but why? Just flip or see. Maybe he's seeing what their next witness is going to be.
Yeah, maybe that's is the next witness within 45 minutes or something like that.
Yeah.
La da 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 dee da dee da da.
Thank you.
No one removed any of your. Zach is such a crybaby. Oh, everyone's deleting my messages. You were just up there. Jamie, I'm going to flip the table in 2 seconds. I'm going to flip the table and start yelling.
Oh my God. I hope you do.
Well, Zach, you're the moron because you complain in chat and I can't see anything getting deleted that YouTube does. Man, maybe don't try and put penis as every second word.
Oh my goodness. Come on, guys. You are the slowest bunch of
I bet you we could end it today and then we could play it in 1 hour tomorrow.
I know. This
It's
trial needs to be on delay so you can fast forward through all this crap.
if you're subpoenaed, does the requested site pay for travel expenses? Or is that your problem? I have no idea. In Denmark, you will, if you're a witness, you will be compensated for your time. You'll get like $15 to show up and testify, and you will have your travel expenses. Everything over 3 kilometers, you will have a fixed rate paid to you. So you will get like $15 a day to testify.
I'm curious if you do. Just do you know? Because sometimes I think they can arrange it with the person if they really need them, but I thought you were kind of on your own. They kind of left you on your own.
If you're in prison, they will arrange your transport, but I don't know how it
Like
works.
if
the
you
other way.
really want a witness to come and you subpoena them, and they're like, oh well, I can't, I can't afford like I could see them like coming up and being like, all right, well, we'll figure this out
Yeah.
because we really need you here. But I don't know if they just like automatically do it.
Zach needs a new hobby.
This is his hobby.
Okay, members of the jury, we are going to take an early lunch break today. Okay, we will take the noon hour a bit early. And so we will break now. We are going to reconvene at 12:45. I'll expect you folks back at 12:45. I will meet with the lawyers before that, but I would ask that you be ready to go at 12:45. It is currently 11:30. Again, consistent with all of my instructions, do not discuss the case amongst yourselves or with anyone else. Conduct no research as to any matter. Don't transmit any matter through your own social media. And if you see someone in Lancaster, please don't talk to them. But other than that, thank you for following my instructions, and we'll reconvene again at 12:45. Thank you. All right.
This is the most disorganized trial we have ever watched. And we didn't watch Del Brooks. They can pay for travel and lodging. It usually gets added as restitution if there is a conviction. If not, it's not automatic though. Yeah, because the Walls had people coming from California and other county as Commonwealth witnesses. Who pays for that? apparently themselves.
Yeah.
Jamie is in Wisconsin.
Oh, God.
You told me
Then
not
the
to
lawyers,
talk
I'll
to you.
just confirm that what I've indicated is we will reconvene court at 12:30. I know that I indicated that the jury.
Even Lorne and Krim got so tired of them, they just, we're going to
Just
put it on the
cut it
spin
off.
cycle.
The jury to be back at 12:45, but my expectation will be to confer again with the attorneys at 12:30, and the court will be in recess from now until 12:30. Is that sufficient, counsel? Sufficient? Okay, all right, thank you.
Yeah, we're going to be back at 12:45-ish because this is going to take forever. So we can just catch up. Jamie lives in the state of confusion. She does.
That is probably, yeah, that's a better.
The Daisy Link trial was chaotic and messy, but not this bad. AKA the Ohio State, Michigan, downtown Minnesota.
All of it. All of the
Yes. Jamie is from every state and no state. The only thing she knows is she is a lover of cheese. And that's all we need to know about Jamie. Jamie works in a public-facing business. That's why she's off screen as much as she is, and she's a little careful now. Back in the day, she wasn't, and of course, on her OnlyFans, she will be more open, but not on YouTube trials.
Yeah, gotta be incognito.
Yeah. Oh, look who is rubbing it in Sue's face. But we didn't learn much today. Wasted most of the morning just to get. They had some kind of plan to take the kids.
Yep.
But there's no indication so far that he had any knowledge of it. There's no indication that she was about to take the kids. Actually, he was the one who was about to leave with the kids. So I don't know in what way they're going to spin it, but it's going to be interesting. And that's why you should come back this afternoon. Yesterday, half of you dropped off at lunch, and I don't blame you because this trial goes on way too slow. Way too slow. So we'll be back at 12:40 or something like that, and we'll catch up because there will be enough sidebars for us to do it. Please do all the things, do all of that dingy dip. And AJ has told me I get it wrong. She's working for the sheriff, not the state. I don't get the difference. It's not federal, it's sheriff now. Still, she needs a little help to get some equipment. I don't get it, Jamie, and I just want her. If someone is wanting to help her out, please contribute to Carmen's safety.
I agree.
Jamie, I'll see you in a bit. I'll go and make
bye.
myself some. I think I'll have some. I don't know, Indian-inspired food. I think I have something in the fridge I can make into that.
Yeah.
Hasta la
Scrambled eggs for me. Bye.
Bye.